Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Jonathon Kappy.
And I'm Jordyn Sanford.
Welcome to Hull on Estates. You're listening to episode number 735. Today, we're going to be discussing AI hallucinations and what can go wrong. How you doing, Jordyn?
Good.
I'm not sure when this podcast is going to air, but it is January 5 today. So we are at the very beginning of the new year, and I think we are starting with a warning to the profession that Justice Myers has said very loudly that everyone should be paying attention to.
Yes.
So listen, we do a lot of investment in AI in our office. We use it, different lawyers use it for different purposes, but we're all invested in using AI to help make our practices run a little smoother, a little easier, a little bit more efficient. And so the story that we're going to talk about today, the case that we're going to talk about today, are some of the warnings that you have to take into consideration when you start using AI. So, Jordyn, I'm going to give you the task of telling us the background as to what happened on this one.
Sure. So this was a decision from Coe and Lee. It began as a motion in May 2025. It is on the estates list. It was a estates and family motion. And counsel prepared a factum that referred to a bunch of cases. And once Justice Myers went to look at those cases online, the links gave him error 404 pages, or some of the conclusions drawn in the factum were not what was actually drawn in the case law. So he asked, at the hearing, he asked counsel to explain, and she said she was shocked and didn't understand how this happened. So he asked her to explain, and she said that it was staff and student who prepared the factum, and she didn't know whether they used ChatGPT or another AI usage to prepare it. So as a result of this hearing and the factum, a show cause hearing was scheduled a couple weeks later. And counsel was to attend that and explain and show cause why she should not be charged with contempt of court. So between that time, she went back and checked with her staff and students, or so she said. And she gave 2 letters to the court at the show cause hearing and an oral statement. She said that she was very apologetic. She said she would undertake to do CPD in ethics and technology and on AI usage, and she withdrew her defective factum. She said that she understood that it was wrong that she didn't verify the links in the factum, and that she would take better efforts in future to verify and confirm any work from staff and students and supervise. So at that hearing, Justice Myers gave some background information on contempt of court and what the court's concern is with these issues. He separated the LSO concerns from the court concerns. He said that the LSO is the regulator of the profession of lawyers, and they're more concerned with supervision, technological competency, whereas that's not the court's concern. The court's concern here is misrepresentation of the law and counsel's duties to be accurate in their submissions and make sure they're not misrepresenting anything that they're signing, delivering, or relying on and making legal arguments. So really, it was misrepresentation of the law that was the main concern of the court. And he cited the leading case on contempt of court, which is R. N. Cohn, C-O-H-N. And he emphasized that counsel who misrepresent the law, submit fake case precedents, or utterly misrepresent the holding of cases, which is all what happened here, violate their duties to the court. So with the apology and the undertaking to do CPD courses and the pushback,
Promise to be better.
yeah, Justice Myers felt that he was satisfied with that she had show cause. She had already received a lot of public outlash as well. So Justice Myers felt it was appropriate not to continue with the show cause hearing. He did cite some of the rules of civil procedure as well, Rule 4.06.1 sub 2.1, which is that you have to certify your factums and to attest to their authenticity. That's a relatively new rule because of AI usage. So he just had to, the factum that the counsel produced did not have the certification. And it just helps to, so all counsel know of their duties not to mislead the court in this regard. As well, the other rule that he referred to was Rule 57.07, which is 2 available cost remedies used by the court to protect clients from being billed for defective work, such as this factum. He could have ordered to disallow costs or have the lawyer repay the client the money paid or reimburse to another party.
Yeah. Yeah, there's definitely cost consequences that are available when this kind of thing happens. You can't charge a client.
Yes,
right?
yes. So
And
yes, Justice Myers felt it was appropriate to dismiss this show cause hearing and continue on with the proceeding in the normal manner. So we thought that was the end of it.
there's always a but.
Yes. So a few months go by, about half a year, and Justice Myers received a letter from counsel, which was not requested. It was an unsolicited letter. He did refer to a Law Society investigation, so this could have come up through that. But counsel admitted that she was dishonest at the show cause hearing, and her submissions were not accurate. She had in fact prepared the factum herself. She did not rely on staff or students to prepare the factum. And again, she went through the same apologies.
Right. But this time she's saying that she lied.
Yes. So this time she's admitting in writing that she's misrepresented the court twice now. Once through the factum that had AI hallucinations, and once through submissions to the court on how those AI hallucinations came to be. So Justice Myers scheduled another hearing as a result of this letter. At this new hearing, he said that the new disclosure, her submissions in the letter, were a fresh act. It's alleged deception in the prior contempt proceeding itself. He reinstated the show cause proceeding, and he actually invited the Crown to participate, and they did. So they appeared at this hearing, and their position was that counsel had misled the court or contempt of court twice. First, at the by the virtue of the factum and including AI hallucinations. And then second, at the show cause hearing itself, when she misled the court, he said this was obstructing and interfering with the administration of justice. And the first factum, he described it as indifference akin to recklessness, which is the wording of the case law R and Cone.
So there's a lot to digest here.
Yes.
Okay, so let's talk about the AI part first. All right, I think there's too many things for us to get through in this entire episode. But as we discussed at the top of the show, our firm uses a lot of AI. And it's a great product. Different companies have different products. It can help you with your efficiency. It can help you do varying things, but you got to be careful.
Yes.
All right. I mean, we've seen not just in this particular case, but there are numerous examples of AI making up cases, making up stuff that doesn't exist, either making up cases completely or referring to cases for a particular principle when the case does not stand for that principle at all.
Right. Yeah.
Um, and so you got to be really careful. Um, I like to think of it as, if AI is doing a task for me, I think of it as a high school student doing the task.
Hmm.
You got to read it, you got to double check it all. They didn't go to law school. They got no legal training. They are doing their best, but you cannot completely rely upon them. And so, yeah, I mean, listen, technology is great, but it creates a new set of problems. We saw it when COVID started and courts started to go online and Zoom and all those kind of things. It was wonderful to be able to go to court from your basement, but you still have to gown. You can't wear sweatpants and your pajamas when you go to court, right?
Yeah.
There's still a decorum that you have to maintain. Um, and we've got this push and pull between the law society and the courts, right? The law society is there. We are a self-regulating profession. The law society regulates the profession, but the court has inherent jurisdiction to control what goes on within its four walls, virtual or not. And so, you can come at it from both ends, and you've got to be very, very careful. And maybe this is the warning that everyone needs. And Justice Morris is right. I mean, this lawyer got a lot of notoriety from this case. And I'm sure that this lawyer is not going to do it again. But it's got to be put on a big board so that everyone sees it and they're aware.
Yeah, it's a great cautionary tale, this case. Um, when you use AI, use it right. Like there's a proper way to use it. And if you're not double checking your answers or the answers it's giving you, then you're going to find yourself in consequences such as these, perhaps.
Yeah. Yeah, listen,
Yeah.
when you write a fact, you fact check everything, right? You make sure that's, if you're going to cite a fact, you make sure that that's what the affidavit says. When you're citing cases, you got to read the cases.
Yeah.
You just have to. That's your job as a lawyer,
Yeah.
right? I mean, anytime you put your signature on a document, you've got to stand behind it, and you've got to make sure that the document is worthy of your signature. So, um, and so if we move on from there, we've got the second part of this thing, which is then the lawyer misled the court, which is
Yeah.
probably where Myers got really mad.
Yeah.
You can understand where someone was late. No, I don't want to use the word lazy, but didn't use AI appropriately. But then someone misled him. And that's probably where he sort of lost his patience and, you know, called the AG's office, said, listen, this is no longer a civil contempt. This is maybe more of a criminal contempt.
Yeah.
And you know, and listen, and that Arcone case is a great case regarding contempt and obligations of counsel within a courtroom. And we encourage everyone to give it a read. Listen, you have an obligation to the court. You are an officer of the court, and you are required to maintain a level of uh, commitment to accuracy and professionalism in a courtroom. Because, I mean, and, at the end of the day, this is what I tell, any associate, and I tell my kids, you know, you only get one name, and if you sully that name and you lose credibility, you're never going to get it back. So you got to make sure that you are always honest and straightforward. Um, and that goes inside the courtroom and outside the courtroom. And unfortunately, this one happened in a courtroom where there's a judge listening.
Yeah.
So do you want to tell us a little bit more about contempt and what, sort of what the test is on contempt, or what the
Yeah.
court sort of made findings are regarding the contempt?
So it's this because this was a criminal one, they even cited the test as the elements of mens rea and actus reus. So that was what the Crown pointed out
Mhm.
with his position.
Right.
So
And
the
so I
other,
think, sorry, please go ahead.
right. The actus reus would be like conduct which seriously interferes with or obstructs the administration of justice, or which causes a serious risk of interference or obstruction. And that part is normally proved just with like the factum having AI hallucinations in it, but it's harder for them to prove the mens rea, the proof of deliberate or intentional conduct, or conduct which demonstrates indifference akin to recklessness. But they found themselves in a peculiar situation on procedure here because the lawyer was making admissions herself. She didn't retain independent counsel. She was very forthright. She knew she was on the record with a court reporter there.
Yeah, it's hard to say that she did it intentionally,
Yeah.
right? No one would have intentionally submitted a factum with errors like that in it.
Yeah.
So I don't know whether or not sort of willful blindness or negligence is, an alternate in terms of a contempt hearing.
Yeah, they focused on the indifference akin to recklessness part.
Okay, so it's a recklessness.
Yeah.
Yeah.
So
And
very
so
interesting.
in the Cohen case, which is a Court of Appeal decision, the court said a contempt in the face of the court may be broadly described as any word spoken or act done in the presence of the court which obstructs or interferes with the due administration of justice or is calculated to do so. Forms of conduct which have been held to constitute such contempt are assaults committed in court, insults to the court, interruption of court proceedings, refusals on the part of a witness to be sworn, or having been sworn, refusal to answer, and the court goes on. So, this is the court having the inherent jurisdiction to control its own process, to govern what goes on, to ensure that not only that justice is done, but so that there's the appearance that justice is done, right? That's one of the objectives. The people have to have faith in the courts. Not that just justice is done, but it looks as though justice is done, and that's part of the process. And that's why the court needs to control it. And that's why the court's authority is separate from the Law Society's authority. They have different objectives, right? So,
Yes.
but this is a warning, I think, to the profession and to anyone. More and more we have a lot more self-represented parties, and they also have to make sure that anything they put before the court, any oral submissions they make before the court, are not misleading, because obviously there are consequences. But I think we're sort of out of time. I think that concludes our podcast for today. Until next time, we want to thank you for listening. I'm Jonathon Kappy.
And I'm Jordyn Sanford.
Should you have any questions, please email us at info@hollandhall.com or contact us through the contact page on our website. Have a great day. Thanks, Jordyn.
Thanks.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.